Good morning. I'm Gary DeWaal, and this is Bridging the Week for June 10th to 14th, and today is June 17th, 2019. The Financial Industry Regulatory Authority reminded members and their employees through a disciplinary action that natural person registrants must advise their employers of all outside business activities outside the regular scope of their employment, even when such business activities may involve any type of crypto asset. Likewise, FINRA, through another disciplinary action, reminded all financial service registrants of the importance of having up-to-date policy procedures that reflect actual firm policies and practices. Summer begins in the Northern Hemisphere this week, and the days, while getting warmer, will begin to get shorter and shorter. So I can enjoy the longer days while they last. Let's get started. Kyung-Soo Kim, an ex-General Securities representative associated with Merrill Lynch, Pierce, Fenner & Smith Incorporated, agreed to pay a nominal fine and be suspended from association with any Financial Industry Regulatory Authority member for 1 month for engaging in a crypto asset business he established without advising Merrill Lynch as required by a FINRA rule. According to FINRA, in December 2017, Mr. Kim established a company to engage in virtual currency mining activities, engage a third party to build and operate computer hardware and software for his company, and paid the third party for its services. Mr. Kim was subsequently terminated by Merrill Lynch in March 2018 for, quote, failing to disclose an outside business activity. There was no allegation in FINRA's letter of waiver, acceptance, and consent publicizing its enforcement action against Mr. Kim that the respondent's company actually engaged in any virtual currency mining activity. Under FINRA rules, no registered person may be directly or indirectly employed in any other capacity in a business activity outside the scope of his or her relationship with his or her member firm unless he or she is given prior written notice to the member. Additionally, a person associated with a member must provide advance written notice to his or her employer if he or she may engage in a securities transaction outside the regular course or scope of his or her employment, including new offerings of securities which are not registered with the SEC, subject to various exceptions and conditions. This latest FINRA action against Mr. Kim, coupled with prior recent other FINRA actions, serve as an implicit warning to FINRA member firms that they should double-check that their written supervisory procedures track applicable FINRA rules regarding outside business activities by their registrants and private security transactions by their associated persons. For more details on the prior related FINRA action and more insight generally, check out the article version of this vlog at www.bridgingtheweek.com. Spencer Edwards, Inc., a former Securities Exchange Commission registered broker-dealer and former member of the Financial Industry Regulatory Authority, agreed to pay a fine of $250,000 and pay restitution to certain customers for, among other things, failing to implement a reasonable anti-money laundering policy from September 2013 through August 2015. During the relevant time, SEI's AML procedures required the firm to monitor customer account activity for unusual volume, size, and pattern or type of transactions, taking into consideration risk factors and red flags particular to the firm's business. Among the dozens of red flags enumerated in the firm's procedures were several relating to the deposit of physical stock certificates involving penny stocks, including a customer engaged in a pattern of depositing stock in physical form, selling the position, and then rapidly wiring out proceeds. The procedures further required SEI's Chief AML Compliance Officer to evaluate and investigate all suspicious activity, including activity regarding penny stock deposits. However, according to FINRA, during the relevant time, no person at SEI followed these procedures to assess potentially suspicious activity. As a result, charged FINRA, SCI violated its rule requiring members to put in place and maintain a written AML program reasonably designed to comply with applicable law. This failure led the firm not to identify or investigate the deposit of SCI's customers of billions of shares of companies with little or no business that were routinely liquidated within days of deposit, followed by the customer's rapid withdrawal of proceeds. Registrants' policies and procedures must address their actual business practices and continue to be reviewed and updated to ensure their appropriateness. Again, for more, check out the written version of this blog at www.bridgingtheweek.com. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. You know where it is. Check it out. Have a great week. This is Gary DeWaal, and until the next edition of Bridging the Week, ciao.